Good morning. Are you Tristan Calhoun? And will your client waive the formal reading of the indictment in each
Quick
case?
pause. When a defendant waives the formal reading of the indictment, that's not rushing the process. It means the defense already knows the charges and is choosing to move straight to the plea. This is efficiency,
Calhoun,
but it
clause
also
number
signals that
25,
negotiations
DCCR
have already happened behind the
1216.
scenes.
Your charge indictment in each case.
He will, Your Honor.
Mr. Calhoun, in clause number 25, DCCR 1216, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in clause number 25, DCCR 1217, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Notice
Bless
this,
you.
two
I have
separate
here on the
aggravated
tablet some
assault charges
documents
from
that
the
have your
same date.
signature on them in each of these
That's
cases
critical.
that the state has marked as
Each
exhibit
charge
number
stands on
1.
its own,
Before
meaning
you
the
sign
court could
these,
have
did you go
stacked
over them with Ms.
consequences.
Holmes? Do you
This
fully
isn't one bad
understand them?
moment. It's two
And do you
legally
understand if
distinct
I
decisions
follow
that
the
now
agreements
follow him
that you've
into
reached with the
sentencing.
district attorney with? Bless you. I have here on the tablet some documents that have your signature on them in each of these cases that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney's office, you will be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind if I follow the agreement. You understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of the cases is for 7-year deferred probations. There would be
This is
$500
huge.
fines.
Deferred
There would
adjudication
be,
is not a conviction.
You'll be required to follow all of the rules and conditions
If probation
of
is completed
including
successfully, there's
paying
no
any
final guilty
restitution that would
judgment.
be determined between
But
now
here's the
and when we
catch,
come back for
violate
sentencing.
even once,
And
and the
also
judge can
having no
sentence anywhere
contact
within the
with,
full felony
the victims
range.
in either of the cases. Do
It's
you understand?
opportunity with a loaded trap
Do you
door.
also understand if there would be $500 fines? There would be you'll be required to follow all of the rules and conditions of probation, including paying any restitution that would be determined between now and when we come back for sentencing, and also having no contact with the victims in either of the cases. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
This warning
It's
isn't
admitted
routine.
in each case.
It's
Is there
federal
any
law
evidence that
colliding
Mr.
with state
Calhoun is
court.
not
No,
competent?
Your Honor.
Even a
All right, sir, I'm
negotiated
going to
plea
find
can
in each
trigger
of your cases that you
deportation or
entered your
block
pleas of guilty
citizenship.
freely and
The
voluntarily.
judge is making it
Find
crystal
that you're mentally
clear.
competent
Today's
and you
decision could
understand
have
the nature and the
consequences far beyond
consequences
this
of those
courtroom.
pleas. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case, both of them, for sentencing so that the probation department can do a pre-sentence report. Again, that'll give me more information about you, your cases, determine any restitution, and then we'll come back later for sentencing. What's the state's position, Ms. Malfino, with regard to bond based on the nature of those plea agreements?
Judge, I have no objection to the PSI bond in this case. It appears he only has one misdemeanor conviction from years ago. For my review of his criminal history, I would ask, as the court has already stated, that he not have any contact with Sierra Williams or Keithera Fowler, the complainants in these cases. It doesn't appear that these parties know one another. It appears like this is more of a road rage, traffic accident gone wrong type thing.
What was the first name, Sierra?
Sierra Williams and Keith Era, Keithera Fowler.
The indictment on that one says Ardwan as the last name. Yeah, that's the 1217. And I can just put
Yes,
both.
it does. So she must go.
Okay, so Fowler, Ardwan.
Correct. correct.
All right, so
That
he,
not, I'm sorry, excuse me.
Sure.
That he not possess a weapon because it was involved in this case. I will get together the necessary documentation for their medical restitution and assist PSI.
all right,
I think the car was still dead. They're alleging the
Was-
car.
the motor vehicle,
They're alleging the car was still dead. It was.
let me look at the probable cause.
There's a,
There-
yeah.
I can't read this. I'm printing something real quick.
Yes, ma'am.
So what I'm going to do while I'm printing that is, Mr. Calhoun, I'm going to I'm going to reduce your bond in each of these cases to $1,000. If you make those bonds, a condition of those bonds are that you obviously have no contact or communication with Sierra Williams or Kithera Ardwan Fowler. Give me just a second. I'm taking that back. I'm not gonna change the bond because there's the potential of some type of
Did you catch that
upfront,
The
either treatment
judge almost
or
reduced the bond, then
cognitive
pulled it back.
issue. I mean,
That's
what happened on
judicial
this
discretion
day
in real
that's-
time.
This is pretty serious.
Once the seriousness
Yeah,
of the
and so,
conduct sinks
the
in,
bonds are going to
public
remain
safety
the
outweighs
same. I'm not gonna
convenience.
reduce those bonds. We'll
This is
see
the
with
moment where
probation,
accountability
what that
overrides
report
mercy.
comes back, and if I feel some type of upfront, either treatment or cognitive issue, I mean, what happened on this day this is pretty serious. Yeah, and so the bonds are going to remain the same. I'm not going to reduce those bonds. We'll see with the probation, what that report comes back, and if I feel like there's anything that is necessary or would be helpful for you to be able to make better decisions, be successful in the probation, then I'll order that at this time, but I'm not going to reduce the bonds based on what happened that day. All right, you can go back with the bailiff. Good morning, you're Donnie Williams. And Mr. Parker, will your client waive the formal reading of the motions in each case?
Yes, Your Honor.
Mr. Williams,
The charges are all the same in each case, Judge.
yeah, I gotta go through them, okay. In cause number 22-40823, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And in cause number 22-41018, I also have a first amended motion to revoke your community supervision. Again, also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. And again, that was a 2-year sentence that was probated for 5 years, correct? And then cause number 22-41019, also have a first amended motion to revoke your community supervision. Also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that also correct? Speak up, please. Thank you. All 3 of these motions allege that you violated your probation. Count 1 alleges in each case that you failed to report as directed to the probation department December of 2024 and January of 2025. And is that true or not true?
True or not true?
True.
Count 2 in each case alleges that you failed to provide verification of completing the theft program or the theft prevention class. Is that true or not true? Count 3 in each case alleges that you did not provide verification of entering and successfully completing the moral recognition therapy. Is that true or not